I want to give special thanks to Plunkett and Cooney and the Michigan State Bar Appellate Practice Section, which have co-sponsored this program and done all of the work in terms of setting up the link on Zoom and the technical aspects. And I want to let you know also that the written materials for this presentation include several articles on appellate advocacy that you can find on the events page of Plunkett Cooney's website. We will include a link to the articles in the chat function of Zoom during the course of this presentation. And we'll also include a link in the survey that we'll be sending to you after this seminar. The mark of a persuasive appellate argument is that it offers the court a path to a decision in your client's favor that seems to the court to be just plain right in light of facts and law. And to offer help to you on how to do this, we are really lucky to have the panel that we have today. So let me briefly introduce them and we'll get started. First, Judge Annika Letica, who currently serves on the Michigan Court of Appeals. Many of you know her from that. You've appeared before her, or you may also know her from her appellate work as a former prosecutor and in the Attorney General's office, where she practiced for many years before the appellate courts. Also with us is former Chief Judge Henry Saad, who I'm pleased to say is now of counsel to Plunkett Cooney and working with our appellate group. He served on the Court of Appeals for over 20 years, and before that had a successful practice in a private practice involving appellate law and many, many areas of appellate law. To get us started today, I wonder, Judge Saad, if you could tell us from your vantage point as a former advocate and a former judge, how we might help the court see our client's position as just plain right, especially in some of the complex or more difficult cases that we have.
Thank you, Mary. And Judge Letica, it's a delight to be with you today as well. And I think everybody who's tuned in to, I know all of us on this panel have histories of speaking with people, but it's generally face-to-face. And so Zoom is a little bit challenging. It certainly is for me, but nonetheless, that's how we're going to do it today. Also, many thanks to the appellate section of the State Bar. Mary Mastro and I did a lot of work together over the years with the Bench Bar Conference, and Judge Letica was very involved with that as well. I think there are three major points that I'd like to make, and hopefully quickly, and then invite Mary and Judge Letica to join with me in discussing those 3 points. As a judge once told me when I went in to argue a case, as he was rubbing his head as though he were in pain, and he said, "Please, counsel, keep it mercifully brief." So I'm going to try to keep this mercifully brief. But there are 3 major points I'd like to make. The first one is to know your panel, know the judges. This does not mean to imply that there is anything nefarious about anybody on that panel, but unless you know who your audience is, we know who our audience is. These are appellate lawyers or litigators who do appellate work, and so we're directing our comments to you. If you're before a panel, let's call it the A team, and you know that A team that you have, let's say Michigan Court of Appeals as an example, hardworking, bright, talented, engaged, asking questions, always on the top of their game, or you have the C panel that doesn't have those attributes. You will argue a bit differently. If you're before a panel, I had arguments before the NLRB, for example. I knew they all knew labor law. They practiced labor law. They taught labor law. They took labor law in law school. You go before the Court of Appeals, you may have the most complex public sector labor law question to come before the court in a long time, and you look at your panel, none of whom took labor law, practiced labor law, wrote in that field, or ever addressed the case that you're about to argue, which is consequential. And our remarks, our directed to consequential, very important key cases. This is not the run-of-the-mill stuff. So if you're going to argue, you have to know those things about your panel. You also must know if they have ideological, professional, philosophical leanings one way or the other. Doesn't mean they're bad, doesn't mean that they're going to give into their ideological preferences, because judges know that when they take the oath of office, they may have a point of view, but they have to put that aside and rule as a matter of law. Nonetheless, ideological preferences, people's history, their experience, and their politics. Somebody comes out of the legislature as the Republican or the Democratic assistant to the chief Senate committee that works on legislation. That's going to have a bearing on their knowledge, on their predilections, and so forth. So you have to know the panel. Judge Letica knows that very well. When she argued cases, she had an acute and keen instinct for who was before her. So did Mary Masseron. One argued in the civil arena, the other in the criminal arena, but the same principles apply. Mary Masseron and I wrote an article for DRI, which Mary referenced a moment ago, which I would commend to you very, very strongly. It's called The First Law of Appellate Advocacy. Know your audience and be able to think like the judge and the court. There are many, many reasons for this. This article is not super long, but it's extensive and has a lot to offer in terms of the various reasons and different aspects of knowing the judge, thinking as a judge, thinking as a court, because your audience will be thinking about what their ruling may mean to the bench, to the bar, to the industry, to municipalities, to their career, whether they'll be reversed at another level and so forth. So very important, all that's contained in the article. In addition to knowing your panel, you have to know your case, of course, very well, and all of you know that. But you should be able to synthesize, summarize in just a few sentences why you should win, why it's important, why it's consequential, why it's fair and just and appropriate to win in your case. You should be able to do that in a snappy soundbite, a few sentences. It should mirror your introduction, because the introduction in your brief should lay that out, because no one wants to read 30 and 40 pages of facts and procedure without understanding why I'm reading what I'm reading, because you need a roadmap. That roadmap or introduction in the brief, much like your beginning of your orals, is going to tell the court, this is why it is important when you're looking at the question of enforced union dues in the public sector where there are constitutional implications. This is why it would violate free speech. And make it clear why that's the case and why the policy of unionization versus free speech has to be balanced in your direction. So be able to do that. As I will read, I'm not going to quote too much, but I will quote from one book that I've read many times, and it's very, very good advice. It says, judges can be persuaded only when three conditions are met. One, they must have a clear idea of what you're asking the court to do, a clear idea. And Judge Letica will be talking about plain English as opposed to jargon later in these proceedings. Two, they must be assured that it's within the court's power to do it. Is it the legislature? Is it the executive? Is it the judiciary? Three, after hearing the reasons for doing what you're asking, they must conclude that what you're asking is best, both in your case and in the cases that will follow. That's a lot to do with thinking as a court thinks. The third point I would like to make before I turn this over back to Mary is this. If you're an actor, you don't go on stage. It's not lights and camera without rehearsing it, without having a dry run, a dress rehearsal. Same thing if you're an athlete in sports. Same thing in any profession. Why an appellate lawyer would argue a case, a really consequential case for the industry, for the law, for your client, lots of money at stake, without going through it at least once in front of a panel of retired appellate judges who've done this thousands of times. The consequential cases will be Socratic in method, as you know. You will be peppered with some serious questions because there will be important but competing, conflicting interests at stake. And you're going to have to be able to understand that and get the court to understand it clearly. which means if it's the first time you've been peppered with serious questions is by that panel, as opposed to a mock appellate court. I've done it before. I've acted as a mock appellate judge. So has Mary. It is a very, very worthwhile thing. The clients love it. You bring your clients and get involved. I would argue, as I have in the past, to moot court teams at law schools, which I've coached, debate teams in high school and in college, you got to argue both sides, not just one side. When we were in debate in high school and college, every week you turn pro-euthanasia against euthanasia, whatever the case happened to be. Same thing in debate, same thing in law school. If you're on moot court, you'll be arguing the case one week, the next week the other. Why? Because the best way to know your opponent's case is to argue their case. There's merit to every argument, even though you may fall in love with your own, the court may not necessarily fall in love with it. So those are the three things. Know your panel, be able to synthesize and summarize quickly, and for God's sake, do a mock oral argument first. And I would urge, even though it's painful as can be, to do both sides, argue both sides before your panel that you hire, and make sure it's a good panel, of course. Of course, I would say Plunkett Cooney has the best, but that would be bias on my part, of course. In any event, those are my comments. I wanted to take 5 minutes. I think I took 7. Back to you, Mary, for any comments on anything that I may have mentioned.
Well, and what I think I'll do is move into the whole question about how to answer questions, which I think follows from what you were saying. The mark of a really fine appellate lawyer, the difference between an A-plus appellate lawyer and a serviceable appellate lawyer, I think, is the ability to handle the difficult questions in a manner that is persuasive. And that's not easy to do. I'm still trying to learn how to do that. I've been doing it 30 years, and I'm sure right up until the last oral argument I give in my life, I will be continuing to learn. But there are some things that can help, some resources and some ways of thinking before you get to the oral argument that I think can be very, very helpful. And one is to think deeply about what are the likely questions. Some of them will be obvious to you as you are working on the brief, but you will often get background questions. And as an appellate lawyer who didn't handle the case in the trial courts, there may be information about the parties involved, about the views, about the record, things that are not in the record but may become a source of a question at oral argument because they create confusion. Try to think about whether any of those exist in your case. The court is also likely to ask questions about the opinion under review. And it's important to really think deeply about the opinion, whether you're challenging it or trying to sustain it. How was the holding articulated? What was the rationale? What were the precedents that the court relied on? Are all of them really meaty, sound precedents? Are some of them likely to be subject to attack? Were any of them precedents from the panel that you're arguing before? In addition, and this next area I think is among the hardest areas to really master and answer the questions well, the court will often have questions about the scope of the rule being advocated. And I've seen, and probably you have seen, lawyers say, well, we should win. We want an affirmance. Okay, that's good. You know the end game. But what is the rule that's being urged? Is it going to be a broad rule or a narrow rule? And if it's a broad rule, are there limiting principles that would prevent the rule from reaching other slightly different factual scenarios that the court might not want the rule to reach? So one example that I could point to, and this is discussed in David Frederick's book on oral advocacy, the court was asking a series of questions trying to determine whether to uphold a Chicago ordinance that was trying to get at loitering by gang members. And it became apparent that the ordinance did not have sufficient limiting principles and that it could end up applying merely because somebody was in the vicinity of a gang member and that person wasn't a gang member at all. And ultimately that ordinance was struck down. But the court came back again and again with slightly different permutations of the facts that this ordinance might apply to. If you have a case where particularly a case of first impression, you need to think very carefully. Sometimes it's difficult because your client wants a broad rule and you'd like a broad rule, but it may be that the broad rule is out of reach. And I at least think, after consulting with your client and thinking it through, I don't do this often, but on occasion you could say, look, we think the rule should be this broad rule, and these are the reasons why. But if the court isn't comfortable with that, here is a narrower rule on which we would still prevail. And you would have that ready. Possibly you would include that in your briefing, but certainly at oral argument, if pressed on that point, you would be able to have a fallback that would make sense in terms of the outcome you're seeking, as well as the rationale that you're urging, and potentially save that case if a court doesn't like the breadth of the rule or is worried about how that rule is going to apply in other future cases. The court is likely to ask questions about precedent, about distinctions in the case law and whether they apply, about the statutory text. And with respect to the statutory text, I also think it's very important not to just look at a single provision, but to look at that provision within the whole context of that statute. So if you're looking at a provision in the taxing code that creates a certain kind of exemption, you want to be able to fit that exemption into the overall tax code and explain, here's what the language says, here's what the language means, but this is why that language makes sense, and my position of how to interpret it fits within the whole context of what this body of statutory provisions that the legislature enacted is trying to do. Yes, Judge Saad.
Mary, very interesting points. How would you prepare for what you know will be some very vigorous, perhaps even hostile questioning from one member of the panel, maybe more, who knows? But you know that person's history, you've read the case law, you've read their opinions, and you know that the direction you need to go, this judge will go in the opposite direction, and that judge is a very active judge. How do you prepare under those difficult circumstances to answer those questions?
Well, you need to have your best answer prepared, why you think that's right or why you think that's wrong. If there's a way you can still prevail while offering a rationale that would appeal to the judge who is potentially going to view your position in a hostile way, you want to have that ready. And if you are appearing before a judge who asks a series of repeat questions that are essentially the same, you want to at least, I would say at least twice, your first answer and your second answer, try to reformulate what you're saying in case your words were not understood, and try to make sure that you're explaining it as clearly as you can. But if that doesn't work, then it seems to me you want to try to move on to other points and hope that the judge won't interrupt a third time. I'm trying to think if I have ever done this. I have seen advocates say, I'm sorry, Your Honor, that's all I really have to offer on that point, and then just move on, because you don't want to use your entire time giving the same answer to the same question to one judge on a 3-judge panel or one justice on a 7-justice court when you don't have anything more to offer on that point. But you need to, and this is hard in the heat of the moment, you need to be sure, and I'll talk about this in just a minute, that your demeanor stays, your voice stays calm, confident, conversational as a professional, and that you don't start to get heated in your body stance, in your language, in a way that suggests to the court that you're really in a fight here. That's not well received. I guess I would say one more thing about the questions, and then I want to just take 2 or 3 minutes to talk about a little more about the style of your answer. What I would say also about the questions is hypotheticals. And again, this is where a moot court can be very, very helpful, because you bring in other experienced lawyers or former judges to help you anticipate what will be the hardest hypotheticals, what will be the hardest, not your facts, but other facts that could potentially come within the rule you're urging that the court may want to ask about, or may want to try to, trap is a harsh word, but if they don't like the outcome because of their own perspective on the law, they may be trying to demonstrate the problems through the question. And you want to have really, really carefully formulated answers. The worst thing to say in answer to questions about the scope of the rule and hypotheticals is, those aren't my facts. The court knows that. They absolutely know that. What you can say is, those facts differ in this material respect, and in my view, it would be an appropriate distinction to limit the rule in this way. You could say that, but you don't want to just suggest, well, because it's not my facts, the court shouldn't be concerned. The court is always concerned, not just about your case, but about how their opinion is going to be used in some future case. And in order for there to be continuity in the law and a rule of law as we understand it, they're supposed to be concerned about that. So the questions are an effort on their part to do their job as well as they can. And we as advocates should accept those as a part of our collective process to come up with a good rule. Let me just speak for about 2 minutes or 3 minutes on style and demeanor. You want a professional conversational style and not a style that would be appropriate for a jury trial. And I think probably everybody on this call knows this. You want to try not to shout. If you're someone who speaks very quickly, you want to practice carefully slowing down. You don't want to read to the court unless it's a sentence. And then there are some substantive errors in terms of style that you can make, which will cause the court to assume that you're not very experienced, or potentially to turn off your presentation. If any judge asks a question, you want to answer the question as directly as you can. If you can say yes or no, say yes or no. If you can't, you need to explain why in a way that doesn't sound like you're obfuscating or avoiding the question. You want to answer the question when it's asked and not say, well, I'm getting to that in part 3 of my argument. The judge has the question now, the judge wants the answer now. And Chief Justice Roberts, when he was an appellate advocate before he went on to the U.S. Supreme Court, used to put his points on index cards and shuffle them so that he could transition from one point to another point, regardless of what order the questions came in. I haven't done it that formally, but that ability to use that question to answer the question and then transition back to the other points is very important. It's difficult, and all of us struggle with it, I think, but it is something we want to work on. You want to be careful in using your own hypotheticals. Many times you can start with hypothetical and it just leads the court astray and down a path you don't want to go because you haven't thought through the implications. You want to be careful about starting off with a proposition that's going to invite hostility from anybody on your panel. And you don't want to re-argue facts that have been decided adversely unless you're talking about a great weight of the evidence or some other kind of thing that allows you to do that. If the facts have been found and you're arguing the law, you're pretty much stuck with the facts, and you have to figure out how there's a legal point that can result in your client prevailing. You want to remember, and this is also hard, especially if the judges are peppering you with questions and not allowing you to finish your answers. Regardless, you don't want to keep talking over them in the hopes that they'll stop so you can finish your answer. That's very poorly received, I think, and it makes them angry and not receptive to the point that you're trying to make. And you want to be careful if you're going to use names, and when I'm in court, I typically don't. You want to be sure you're using the right name. There was amongst Supreme Court advocates, at least for a long time, a discussion about some poor advocate who went before the court and was calling O'Connor Ginsburg and was getting the names mixed up repeatedly until it became a joke of the justices. And that's a horrible position to be in, and certainly not what you want. So if there's any doubt in your mind about using names, you don't need to use names, and you can still be perfectly respectful and not have any kind of problem. And finally, in terms of decorum, it's generally ill-received to attack opposing counsel. There are rare cases involving egregious issues where the issue is, were sanctions appropriate or something like that. But normally you're not going to get points for making a blatant attack on brother or sister counsel. And you're going to divert from the merits of your own argument, I think, if you try to do this. Sarcasm is very poorly received in appellate courts, and I would avoid it. Justice Thurgood Marshall said, lose your head and you lose your case. And that is really true. You don't want to show anger. You don't want to show frustration. Almost none of us can use humor effectively in an oral argument. If there are people who know that they can do that, more power to them. I have very rarely seen humor used effectively in a court, and I personally would never try because that's not my gift. And you don't want to be too informal with the court either. I mean, these are respected people within our legal system, and so you want to show that respect to them in everything that you do in the courtroom, whether you're making your argument or whether you're sitting at counsel table. And I guess the final thing is, and this is more apparent on Zoom, but it's also apparent in a live courtroom. If you're sitting at counsel table rolling your eyes or shaking your head or making gestures because you think the other person is misstating the record or saying something that is wrong, that is generally not well received. And it doesn't look to the court as though you're a proper professional treating the brother or sister opposing counsel with respect. And because particularly in the appellate world, we tend to be more collegial, those breaches of decorum can, I think, really hurt us if we engage in them. I've spent a lot of time, more than I had hoped, to go through a few of these points very, very quickly. But now I think it would be really helpful if Judge Letica, who has so much experience on both sides of the bench, would share with us sort of, now that you've been on the bench for a number of years, what are you seeing that you wish you had known when you were on our side of the bench presenting arguments?
Well, thank you, Mary. As a longtime member of the appellate practice section, I'm excited and I have to admit a little nervous to be here today, but I am looking forward to sharing a few ideas about effective appellate briefing and oral argument, and in particular reflecting on the transition from longtime appellate practitioner. Mary, please don't say how long. I don't need that out there. But I am one of 25 Court of Appeals judges, and a newer one at that. Outside of oral argument, I sum up my work in 4 words: read, research, write, repeat. Okay? At its core, the Court of Appeals is an error-correcting court, and also one of the highest volume intermediate appellate courts in this nation. Each panel every month, and there are numerous panels, will be responsible for digesting 30 cases. With that in mind, the word and page limit of our appellate rules is not a challenge, it's not a goal. If it was, my colleagues and I would be reading the equivalent of War and Peace twice every month, a feat that requires about 80 hours. So you do the math. It does not work, right? This is my plea. Get to the point. I think Judge Saad hit on it. Mary hit on it a little bit. As Judge Saad mentioned, one wonderful way to do that is to begin with an introduction, highlight the issues, explain to the court why the case matters, and also why you win. This gives your judicial reader a roadmap. Select. Think about the issues that you're presenting. A federal appellate court recently opined parties often raise a large number of claims on appeal, but that doesn't mean that they should. Spoiler alert, the opinion did not end well for the appellant. I once read a brief that had 18 issues. I really think that was a record. And when I got to the last one, it was the only one with potential merit. Please don't employ the kitchen sink approach when you're selecting issues. Instead, I suggest to you that issue preservation informs issue selection. Think about whether the issue may be preserved for appeal at all. It drives the standard of review. Waiver, for example, extinguishes error and leaves nothing for the appellate court to review. A waived issue is dead on dead on arrival. DOA. I would try to avoid those. On the other hand, you also have issues that are preserved by objection. Those are reviewed for an abuse of discretion, and certainly higher hurdles exist for unpreserved error. There is a reason that the appellate briefing rules require the appellant to identify whether and exactly where in the record an issue is preserved, along with the applicable standard of review. It really does drive the decision. Once your issue or issues are selected, please be concise and clear in your legal analysis and your writing. Good arguments can get lost in bad writing. Humorist Will Rogers once remarked, the minute you read something that you can't understand, you can almost be sure that it was drawn up by a lawyer. Please don't be that lawyer. As Judge Saad mentioned, a skilled appellate attorney is able to boil down a legal argument to a few short sentences. If you start seeing sentences that are paragraph-like in length, or an argument that runs on for uninterrupted pages, it's time to pause, it's time to rethink, and it's time to edit. Break down, if possible, the legal argument into subheadings. Help your judicial reader. Former Chief Judge of the Court of Appeals, William Whitbeck, once explained, to win with judges, and this flows with exactly what Judge Saad was talking about, you must make what is complicated clear. You must make what is confusing simple, and you must make what is disputed understandable. You don't do this because judges are simple-minded readers, but you do this because you realize that every month I'm reading 2 times the equivalent of War and Peace. Simplicity, clarity, organization, and logical progression are keys to winning on appeal. What is unhelpful, and Mary already mentioned this, and I'm so glad that she did, personal attacks on your opponent, not helpful. And I would add, Mary, too, likewise, personal attacks on the lower court make you shut
Absolutely.
down. Okay, right? Let's talk about the statement of facts for a minute. The appellate briefing rule requires a clear and concise and chronological narrative. And who doesn't enjoy a good short story, short with a beginning, a middle, and an end? Reciting a witness-by-witness account or a filing-by-filing account may show that you've read the transcripts and reviewed the record, but it is not a story. Telling a story is memorable. Please spend time crafting the story you want to tell. I appreciate visual images. Cliche as it is, a picture can be worth 1,000 words. And because I'm a directionally challenged individual, a sketch depicting a car accident is clearer than a wordy description, wait, which way is north, that I have to unravel, okay? This applies to your legal arguments as well. Recently, an appellate attorney perfectly encapsulated his legal argument in a chart. It was both eye-catching and persuasive, and everyone on the panel agreed, and we complimented him on it, and he said, this is the first time I've done that. So it was very, very effective. In your statement of facts, please don't ramble on and on about dates or irrelevancies. Stick to the relevant and material facts, but you have to include both favorable and unfavorable material facts. Confronting unfavorable facts head on and neutralizing them in your brief is better than having the judicial reader see them for the first time in the opposing brief and then potentially ponder what else did the advocate admit. Above all, please be candid with the court. It's your ethical obligation. Some time ago, an attorney in a brief argued that his client was entitled to a new trial because the prosecutor had described the testimony of a now recanting witness as, quote, the linchpin of the prosecution's case. But as explained in the opposing brief, the prosecutor had actually argued, quote, the defendant wants you to believe that the witness was the linchpin of our case. So while the advocate was able to explain later why this occurred, it consumed time during oral argument. Now, let's talk a little bit about oral argument and what I fondly refer to as the speech. Mary, can you recite the speech? I'm sure you can. I know you've heard it hundreds of times, Judge Saad. I know you've probably given it hundreds of times. The presiding judge will welcome the litigants for the day and explain in short, we're prepared. We've had the benefit of not only your briefing, but also of the court's internal staff reports and in-chambers work. We are familiar with the facts and the controlling law, and with that, we'll call the first case. And so I'm here to tell you that's true. And so it flummoxes me and also annoys me when litigants launch into a detailed factual recitation, or worse, start to read verbatim from their brief while flipping through the pages in a monotone. All right? Oral argument is your opportunity to converse with the judges and engage as part of the decision-making process. The best advocate, and Judge had already mentioned this point, is to succinctly state why your client should prevail. And to quote one of my colleagues, tell me in a sentence why you win. Okay, that may be a bit ambitious in a complex case, but it highlights an important point. Whether your appellate brief is lengthy or truly brief, ask yourself, what is the most important point, or what are the most important points I want the court to understand? Distill your central message into a concise presentation. Again, using all of your time is not a goal or a challenge. The math just doesn't work. We have a certain number of cases scheduled for a 2-hour slot. We could be there all day, but I don't think that would advance anything. We've already had the briefing. Think about what you want to distill from that briefing. If you are the appellant, you're likely going to have a bit of uninterrupted time to make your major point or points. Use it. Use it. State why your client wins. Do it persuasively. Explain your client's position in relation to the law, the standard of review, issue preservation, and the facts. And when you represent the appellee, you've already had the benefit of hearing what's come before that. All right? Point your argument to that you've already heard, and especially any questions that the panel has asked. Mary, you mentioned always know the procedural and factual history of your case better than anyone else. If the judge asks you about facts or procedural history and your answer is, I don't know, or I don't know because I wasn't the trial lawyer, you have missed an opportunity to aid the court's decision-making process. For the reasons detailed by Judge Saad, learn about the judges assigned to your panel. I myself recognize that my colleagues have unique backgrounds and join the appellate bench via varying routes. I'm fortunate to be able to tap into their earlier specialties because we are now all generalists. We address every type of legal question, and every month it can go from tort, property, business, probate, tax, family law, criminal law, child abuse and neglect, okay? At the very least, our biographies are available on the court's website. Research whether the judges have written or were panelists on arguments that address the issues raised in your appeal. Again, some judges may be experts, as Judge Saad mentioned, in the subject matter of your case, while others will know little to nothing about it. Speaking in specialist jargon is not going to be helpful to those judges who don't know that area of the law. And as Mary pointed out, we're not a jury. Please lose the theatrics. Your focus should be on the law and the facts. And Mary, I've had those people that start at 100. They get up and they're angry. I've had to stop them and say, excuse me, counsel, I don't believe you've placed your appearance on the record. They become so personally invested in the client that they lose the objectivity and the professionalism. And I will say, my pet peeve at oral argument, and this has happened even when I'm on a panel with 3 women, inevitably one of the litigants will refer to us as you guys. Okay. I mean, it needs to be a little more professional than that. And when I mention that to my husband, he'll always say to me, "Oh, it had to be somebody younger." But I don't know if that's necessarily true. But that is definitely, you should act in a professional manner, and it is expected. All right, Mary, 100%. If a judge asks you a question, stop talking. The judge wants information, or the judge wants to test your argument. And sometimes the judge may even be attempting to address a concern that they know that their colleague has. Don't assume because the question is negative to you, or in your mind negative, that judge is opposed to your position. It may not be so. as Mary has fully discussed, be prepared to answer questions about the troubling, factual, and also the legal aspects of your case. Mary, have you ever had a case where you did not have a legal position that had a problem or a vulnerability?
There's always something.
There's always something, right? So list those problematic issues in your case. Flag your opponent's strongest arguments and your weakest points, right? That's the way, as Judge Sod mentioned, you're on the debate team and you take the other side. That's how you learn, where are my strengths, where are my weaknesses. Reread the law at play and perform additional research to update. I know, and I think we're getting better in our disposition speed on cases, but still, it'll be months from the time that you file the brief to the time that you appear for oral argument. Always bring to the panel's attention recent binding case law. I had an argument where it was an issue of first impression, and the attorney said to me, well, last week a panel decided, and I thought, why didn't you file a supplemental authority to bring this to our attention? I do try to read our opinions and keep up, but sometimes you miss things, or you have put it aside to read it at a later point. But as soon as I heard that, we have an internal rule that we are bound by prior published authority, unless we disagree with it and we ask for a conflict panel. And if you have not read Mary's best practices for oral argument provided for you as part of this presentation, do so. She is correct that oral argument is an important opportunity and may turn the tide in your client's favor. Just said, I know that it's happened to me where oral argument has changed my mind. Has it happened to you? Have you been persuaded during an argument? You went in thinking one thing, and I will say it's shocking to me that people really don't expect us to be prepared. We've been living with the cases for a month. We are prepared. I read every brief. I read the reports. I read the memos. I am ready, and you'll probably know it because I'll stop you when you're talking about your facts and inject one. So Judge Sod, do you have any thoughts on that point? Has oral argument changed your mind?
Judge Ledick, I think that's an excellent point. Many people believe that, given our appellate system, that people are already dug in after reading the briefs, and that oral argument, as many of the books have said, is just pro forma. But if you're talking about the kind of case that is complex, consequential, case of first impression, these are the kind of cases we're really focusing on today. And you can read the brief, but there will be questions because there are countervailing considerations. There's public policy involved. Often it's interpretation of a constitution or statutory law or regulatory matters. And it's not that simple. And that's when you get the questions that helps the panel decide. Oftentimes, you will be unsure. There have been many times where I have been unsure after reading voluminous information in an arena that's complex, nuanced, and there are very difficult questions that have to be answered. And you look to the advocates, the people who practice, the specialists every day, and you ask the question, why does this matter to Treasury if this particular regulation is not followed? How does this affect municipalities throughout the state if we were to rule this way? Because that's not necessarily intuitive. Oftentimes
Correct.
You may ask for amicus briefs for the very reason that we're talking about right now. So yes, if the case is consequential and complicated, often with a matter of first impression, distinctions have to be made, as Mary talked about, where does the rule end? Where can it unravel later and hurt future cases? Think as the judge is thinking. When you walk into that courtroom, that oral argument can be very, very important. And I would involve the client as well, especially if it's important to the client and that industry and amicus briefs. Get them involved in the mock oral argument. They oftentimes know better than the lawyers what the facts on the ground and how it will affect them. So
Right.
all to your point, yes, great. So,
Yes. What are the real world consequences? And I appreciate having that information. Mary,
Yeah, I was just going to say two things. First, if you have questions for any of us, please use the chat function and type your questions in so that we can try to answer those we can get to. And then the other thing I was going to say, and this goes with knowing your court, we have largely been focusing on the Michigan Court of Appeals, and there's a couple of important factors that relate to the Michigan Court of Appeals. One is, as both of the Judge Stott and Judge Letica have said, it's a high volume intermediate appellate court. That means if many of the cases are going to be bound by controlling precedent already, either from that court or from the Supreme Court. And in Michigan, and this is true in a number of state intermediate appellate courts, there is a very large staff preparation, pre-argument preparation function that goes on because of the court's pre-hearing staff. And the judges on the Michigan Court of Appeals have the benefit of that, as well as their own clerks and their own review. So when they come in, they are not new to the facts and law of this case. They may have circulated a potential opinion. That's a little different than a court, such as a court of last resort, which is not bound by prior precedent, although there are stare decisis implications. And it's a little bit different in a court of last resort because the cases in which they're likely to hold oral argument are cases in which the law is either not settled or the settled law is for some reason coming into question as to whether it should be expanded or contracted or overturned or whatever, applied in some entirely new factual situation created by new technology and so forth. And so the kinds of questions you're going to get and the amount of pre-thinking that the judges have done and the direction of the pre-thinking that the judges have done is going to vary. And I just have one more point on this, which is a sort of practice pointer that goes to anybody who is charging their client an hourly fee. I think it's or if their client, even in a contingency fee, if the client is coming to court, I think it's important to explain to clients that if you are on a busy intermediate court, which gives you, in theory, a full 30 minutes to make your case, but anticipates that in most cases, the advocates will be skillful enough to focus in on the key linchpin and they won't need that amount of time. You need to explain that to your client. And from a billing perspective, I tell clients, and this is absolutely true, that the shorter the time you have, the more intense in certain ways your preparation has to be, because if you are not fully prepared with cogent answers and with record citations to key facts so that you can quickly answer, you're not going to have time to fumble around searching. You're going to miss the opportunity. And that is why, even though you're only speaking 15 minutes or some pretty short amount of time, you may be spending 20, 30 hours or more in a really difficult case in order to be able to use that time well. I think clients understand that when you explain it, and especially if they're coming to court, they then understand better the dynamics of what's going on.
Mm-hmm. I agree. And Mary asked me to talk a little bit about Zoom. So what I'm going to say is that Zoom is going to continue for the Court of Appeals, I believe, until at least September. And its future role is under consideration, but I predict that it is here to stay in certain circumstances. So if you participated in Zoom arguments, I really would welcome your feedback, negative or positive. And if you haven't appeared for a Zoom oral argument, the court does have some specific instructions for you as an attendee. So please review them for information on settings, signing in, and certainly troubleshooting. Practical considerations, and I think we ran into some of those today, are location. Choose a private, quiet room, one free from interruptions. Think about the extraneous noise in the environment. Certainly silence your phone, your cell phone, and your other devices, and consider other residents and pets. I think we had a dog running through the room yesterday while we were on, on the Zoom. But calling in from an outdoor venue or from a public place, that is not professional and not acceptable. Lighting, we have here good consistent lighting. Avoid rooms with bright windows, because if you have backlighting behind you, we had an attorney argue that we could not even see at all. So be aware of that. Also be aware of your background. The camera sees everything, okay? Use an appropriate and professional looking background, unless you are looking for that viral moment of I'm here live and I'm not a cat. We'd like to avoid that. Know that what is behind you is in the camera's view. So your background should be just that. It should be background. Please don't let it distract from you or your presentation. Appropriate background. I think we've all got one on this call. A blank wall, an uncluttered office, an organized bookcase. I've seen liquor cabinets, sports memorabilia collection. That takes your attention away from the advocate and what point you're trying to get across to the court. Okay. On Zoom, it is a little bit more difficult to listen for questions from the bench and pick up visual cues. But again, when a question is asked, stop talking, answer it, and move on. And please, please don't say, I was getting to that, so just hold on. As I said, the court's asking for a reason. Camera placement, please keep the camera at eye level. I really don't want to be looking up somebody's nose. If you look at the screen, you will appear to be looking down when you're arguing, okay, and the judges will have the impression that you're reading, and rather than having a conversation with them. As a recent litigant in our court learned, the camera really does see everything. No gestures, as Mary pointed out. Your attire, I think we all have professional attire, and a professional appearance is important. In the world of Zoom, some people think that it is appropriate to just have the top half because that's all that can be seen on Zoom. Or is it? I would recommend being appropriately attired fully in case the camera does end up in a place where you don't want it to be. If you run into a technical difficulty, please don't panic. It happens. I've dropped out of Zoom calls as a sitting panelist. I've had people drop out of Zoom calls. Just contact the number provided and attempt to rejoin as quickly as you can. So with that, Mary, I think those are all the remarks that I have. And if anybody has any questions or feedback on Zoom or anything else that we've discussed.
And I see that we have reached the end of an hour. So I want to thank you all for coming and for participating. I hope you found our comments and discussion helpful. I hope you find the articles helpful. It's such a joy to participate in oral argument, and maybe more so in open court than on Zoom, but it's the public nature of the oral argument that is part of what the country sees as the operation of the rule of law. And we are all so privileged to be lawyers and judges in a country that values the rule of law. So I commend to you the joy of practice and wish you the very best in all of your future oral arguments, that you walk away from them, whether you win or you lose, feeling that you've acquitted yourself well and that you've represented your client well and that you've made the points that were there to be made in that case with the court and with opposing counsel, so the court reaches the best outcome. We will be sending an email that will have a survey about this, and it will also include a link to the written materials if you did not already get them from Plunkett Cooney's website. And once again, if you don't belong to the Michigan State Bar Appellate Practice section, I would encourage you to join. It's just a terrific, terrific way to meet other people who do what you do, to learn from them, and to enjoy the pleasure of their company at the many section activities that go on. And with that, I will thank you very much, and I think our meeting will be concluded.